All right, welcome back. Now let's go ahead and talk about some legal and ethical frameworks. There are a lot out there, so obviously I'm not going to be able to cover everything, but I just wanted to kind of highlight on a few of the big ones and some key similarities between them and kind of how to evaluate all of this. So, when it comes to cybersecurity laws in the US, the big one is the Computer Fraud and Abuse Act of 1986. It was later amended in 2008. And this is a law that really criminalizes unauthorized access to computers and computer networks. As a penetration tester, if you violate the rules of engagement, you exceed the scope, you would fall under the Computer Fraud and Abuse Act. So don't do that. You won't have to worry about that typically. Not all the times, but typically. The other big one is the Health Insurance Portability and Accountability Act, or HIPAA. That was enacted in 1996, and that protects the privacy and security of individuals or individually identifiable health information. The security rules set standards for electronic PHI, and it really adds teeth to if someone accesses your medical information or someone knows of medical information that was leaked, then there are severe penalties for that. There is the Gramm-Leach-Bliley Act of 1999, and this is where it requires financial institutions to explain information sharing practices and protecting consumers' private financial data. So there's a lot of importance on protecting the information, specifically financial information for that particular act. There are other acts, but the big one is going to be that Computer Fraud and Abuse Act, and that is really the law that allowed the government and law enforcement to go after individuals committing cybercrime in the United States, and it's all kind of been born from that. There are also various privacy legislations which are out there. The big one internationally is the GDPR, which is the European Union General Data Protection Regulation. This is also kind of known as the Right to be Forgotten Law, and it applies for any European Union citizen, although the penalties for it are severe enough that organizations all around the world generally tend to conform to the GDPR laws and apply the pretty much the same thing. There is the FISMA, the Federal Information Security Modernization Act, which requires U.S. federal agencies to develop, document, and implement information security programs. And it assigns NIST, the National Institute of Standards and Technology, the responsibility for creating security standards for federal systems. And those security standards are actually used by private organizations all the time. It's generally seen that whatever NIST recommends is what people should be using all over the place. There are state-specific privacy acts. The first one was the California Consumer Privacy Act, which was generally tried to kind of emulate what GDPR does, just at the state level. Colorado has their own Privacy Act, which went effective July of 2023. The teeth of those particular acts are for any residents of the state, specifically like the Colorado Privacy Act, if information got leaked or there was a compromise, then businesses had to inform the citizens of Colorado that were affected by this within, I believe it's 30 days, that their information was leaked. California has different restrictions for that. I'm not sure what those are off the top of my head, but most states these days have some sort of privacy act similar to the California and the Colorado one. There are also a number of security standards out there, and there's similarities between there. So there's the NIST Cybersecurity Framework, which was like I said, created by the National Institute of Standards and Technology. This is a voluntary framework of standards, guidelines, best practices to manage cybersecurity risk. There were 5 core functions: identify, protect, detect, respond, and recover. Um, the new version, which came out in 2024, added a 6th govern function. And those 6 core functions are all of cybersecurity. There's also International Organization for Standardization, ISO 27001, and this is the international standard for how information security management systems should work. It's a certifiable standard where if a organization wanted to be ISO 200 or 27001 certified, then they would get audited on that, and they would have to conform to certain policies and procedures. It's really a way that a consumer or other businesses can look at that business and say they are doing things a certain way to be more protected for cybersecurity. On the payment card side, there's what's known as the PCI DSS, which is the Payment Card Industry Data Security Standard. This is a set of rules and guidelines for how businesses can store and process, transmit cardholder data. It was a council made up of Visa, MasterCard, Amex, Discover, and they got together and they came up with these particular requirements and standards for businesses. If a business doesn't follow these standards, then they could lose the ability to actually take credit cards, which is a really crippling thing for a business. So businesses tend to follow the PCI DSS standard, and that has overall improved the security and the privacy for card holder information. There are several ethical frameworks out there. 2 of them here is the ACM Code of Ethics and the ISC2 Code of Ethics, the International Information System Security Certification Consortium. There are a lot of similarities between all of these. So ACM, for example, states contribute to society and human well-being, avoid harm and be honest and trustworthy, be fair and take action not to discriminate, respect privacy and honor confidentiality, and respect intellectual property rights. Whereas the ISC 2 Code of Ethics is protect society, the common good, and infrastructure, act honorably, honestly, justly, responsibly, and legally, provide diligent and competent service to principals, and advance and protect the profession. You'll find a lot of other ethical frameworks that detail or state pretty much the same thing, because there's a lot of ethical similarities between all of this. Generally, what you should do is act in an ethical manner. Don't try to cause harm to other systems or users or software or anything like that. Don't discriminate against others, and just follow good ethical guidelines for all of that. So in practice, there are several ethical principles, but privacy, which relates to data collection, retention, access boundaries; responsible disclosure, which we'll talk about, is reporting vulnerabilities ethically. And there are ethical ways and non-ethical ways to report vulnerabilities. Ethical hacking, so authorized testing within defined scope. There's a common theme with the penetration testing of not exceeding the scope. Well, that's the ethical hacking. There's also surveillance and security, so monitoring and individual rights, and kind of how those work together or don't work together from time to time. So privacy. Ethical practitioners ask the foundational questions before collecting data. So what should be monitored? What data should be collected and retained? Who should have access to that data? And these are difficult questions to actually answer, because what should be monitored can change depending upon the particular context. If it is a business, then Systems should be monitored. Employee accounts should generally be monitored. In the US, an employee doesn't have any expectation to privacy when utilizing business equipment and devices. Outside of the US, that's a different matter. I believe the European Union, you do have an expectation to certain privacy, even with an employee's or an employer's equipment. So if you happen to log into your personal email account on an employer's computer, they would not have the ability or legally to monitor what email you are reading or your personal email. What data should be collected and retained. So typically you want to try to collect the minimum or whatever is necessary. You want to also have a defined retention period. So don't try to keep all data infinitely or indefinitely. Access logs are a good thing. So when a user logs in, that should be logged, and digital forensics will look for those particular logs and look for the artifacts of someone logging in. But a strong privacy policy, especially at businesses, will state that those logs should be rotated on a regular schedule. Now, that kind of runs afoul of the digital forensics part where they need to potentially go back longer length of time, but you kind of have to balance the privacy with the security aspects of it. Who should have access to that data? It should only be the people who need to have access to it. So access logs, for instance. Not everyone needs to access those. It should really be down to a security team or systems administrators or the particular server administrator for that group of servers or those group of accounts. Web access logs are similar. It should be limited in scope as to who actually has that. So you want to have role-based access controls and other methods in place that will restrict access to logs that would not normally need to be accessed. You also want to audit any of those access logs regularly, revoke access when roles change. So one of the things that penetration testers will look for are accounts which are abandoned and still have privileges and permissions, accounts which stick around after an employee has already left, and also accounts which have access to things which they shouldn't normally have. Let's talk about responsible disclosure now. So as a penetration tester, you may find systems which are vulnerable to various attacks. And you may also be, say, examining some software package and identify a vulnerability in that software package which hasn't been reported before. So when you find anything like that, you document all the technical details, because it doesn't help to just say, oh yeah, there's this vulnerability in this section here. Usually you need to have specific details, specific information, and enough information that when you report it, they could replicate that particular vulnerability. Once you have that, then you notify the vendor. And the vendor could be a security engineer, it could be a developer, it could be a lot of software platforms these days have bug bounty programs, and that is who you would end up notifying. And so when you notify them, you want to have all those technical details and notify them of that. You don't ever publicly disclose it at this particular stage. Once you have notified them, then you typically have a remediation window. So Google's Project Zero has a standard 90-day remediation window. So that window is once you report it, it starts the clock. And the vendor has 90 days to patch the particular vulnerability and roll those patches out. And at that point, after the 90 days, then you can go ahead and move on to the public disclosure phase. talking about the remediation window for a moment, there is another type of vulnerability known as a 0-day, which is a vulnerability which is previously unknown but under active attack. Usually the remediation window for a 0-day is much tighter because it's under active attack. And so a responsible disclosure is you want to get that information out to the public so that administrators and users can take steps to fix the problem, or at least block access to the affected system until a vendor patch actually comes out. So you still need to have some sort of remediation window. At least with 0 days, it may be as short as a week or even a day. It just really kind of depends. I would just recommend doing some research online and see what are common remediation windows. Once you do a public disclosure, then you as the finder of it would be allowed to disclose everything about the particular vulnerability, including proof of concept attacks and full technical details and of the sort. There will also be typically a CVD or coordinated vulnerability disclosure for the recommended framework. There may be some other automated or framework type values associated with the particular disclosure. But once it's disclosed, then it's publicly available and anyone would be able to see what goes into it. So it's important to follow the remediation window and not disclose that until that window has elapsed. So like I said, during penetration testing, if you indicate any critical, or if you identify any critical or actively exploited vulnerabilities, you notify the client immediately. You don't wait until the end of it. If it's under active attack, then you want to let their security team or IT or whoever your point of contact would be that, hey, this is a problem, needs to be taken care of right away, and work with them to try to remediate that. Talking about ethical hacking, the four non-negotiable principles for any authorized security test. Make sure that permission exists. Don't just start poking away at a server or a system unless there's explicit permission. Implied permission is not sufficient. Generally, you want to have a written signed authorization form with the particular system owner. Should specify the scope, testing window, everything else. Again, testing without permission could run afoul of the Computer Fraud and Abuse Act or any other international laws. I will say that even with permission, there are still some situations that you could be detained or investigated due to maybe you have a very clear signed authorization from the organization, but they're having you test something which they may not have authority over, but they don't disclose that. So it is a little risky as a penetration tester to do these things which you feel like you have a clear authorization, but you just have to be aware that sometimes there are edge cases where maybe you don't have the authorization that you thought you did. So whenever you're doing stuff, make sure that you maintain all that documentation. So if anything happens, then you can point back to, this is the individual who said that I have the authorization. These are the steps that we went through, and kind of approach it that way. You also want to have a limited and defined scope. You don't want to exceed the scope. Stick within the rules of engagement and don't violate that. Like it says, even if you discover adjacent vulnerabilities or anything like that, don't exceed it. Scope creep, don't exceed. Don't let the scope creep out beyond whatever is written down and documented. You want to minimize the harm. So, like I said, if you're doing a test and you come across a critical system, probably don't test on that critical system. If that system was previously unknown, and even though it may fall in scope and you identify it, stop testing on that. Don't do a denial of service attack against active servers which are being utilized. Avoid actions that could destroy or corrupt data. So, if there is a vulnerability that may crash a system, don't run that vulnerability. Just say, hey, this system is potentially vulnerable to this particular attack because of this version. We didn't run that because we did not want to crash the system or bring down or cause any damage. And then ultimately follow responsible disclosure. So make sure that you follow those 4 steps for the responsible disclosure. Also, keep things confidential. So treat all client information strictly confidentially. Don't run a penetration test on a environment and then go write a blog post about what you found out. So those are going to be the 4 ethical hacking principles that you need to follow. And the final thing is surveillance versus security. And so as a security professional, then you have to balance monitoring with privacy rights and ethical obligations. So employee monitoring, again, in the US is you have no expectation to privacy as an employee typically. And so monitoring network traffic, monitoring user accounts on systems, monitoring logins, all of that is typically allowed and legitimate. There is some guardrails in place to where you don't go diving into a user account unless there's a business need or an express purpose for that. So that's one of the ethical considerations to take into account. There's also system monitoring. So you want to monitor performance for all the servers and public-facing systems and sometimes employee systems, uptime, error logging, security event logs. A lot of this stuff is going to be automated with notification alerts, which will be sent out if something happens. But it's still good system monitoring, account monitoring, and employee monitoring can capture a massive amount of information that gets stored into databases. So there needs to be really strong control so that not anyone can just access the information. Some of the ethical tension points, if you will, backdoors to encryption. That's a pretty big conversation these days where a lot of governments want to have a backdoor into encryption schemes because if criminals are using it, then law enforcement wants to have a way that they can reverse the particular encryption and go after those criminals. Well, the problem is if there's a backdoor that one group can access, how many other groups can access it? So it's weakening general security for everyone, and it's not really solving the big underlying problem. Overly broad monitoring can suppress free expression and whistleblowing. Whistleblowing is a pretty big thing that should happen because if a business or a government entity is doing something unethical or illegal, then there should be a mechanism in place where an individual can report that and not face punitive measures. And there are whistleblowing laws in place, but there are always attacks against whistleblowers and businesses and even governments want to try to suppress certain whistleblowing activity just because of the implications of all of that. So security controls, and if you are a security analyst or a security engineer, they shouldn't be weaponized to silence legitimate internal dissent. It should be there to just protect the systems and protect the users and the environment. Also, scope and proportionality. So surveillance must be proportionate to the threat. So don't just bulk collection of all data on all employees to catch one bad actor. It's there are reasons to collect a lot of that data, but at times you may have to do more broad collection to try to identify a specific attack or individual, but make sure that whatever you do is in a very scaled down manner or as scaled down as much as possible. So there's no easy answer to any of this stuff. It's just whenever you try to do anything or whenever you're about to do anything, look at it through a legal lens and a moral and ethical lens and take appropriate steps based off of all of that.